Part heard appeal in the matter of C. Stonehenge, Wiltshire, Site Limited, and Secretary of State for Transport and others.
Thank you. Yes, this happened. Just before we get going, I'm told there is some building work going on outside. You may have heard it, but at the same time it's rather stuffy in the courtroom, so we've opened the windows, but if the noise gets too much we may have to close the windows. But I took the view that we should have the fresh air, put up with the noise.
I'm grateful, particularly for the fresh air.
Is it, how bad, you've been in here for a few minutes I imagine, I mean, how bad is it?
It's warmer than it is noisy, I think.
Okay, right. Well, we'll stick with that decision then.
Thank you, my lord.
All right. Do we need to do any housekeeping on,
Yes.
on those documents that we had last night?
Yes, my lord.
Yeah.
So, might I suggest sensible places for them to go? Your lordship should have paragraph 15 of the operational guidelines.
Yes.
And if I could suggest those go into tab 58 of the authorities. The court already has a portion of the operational guidelines. And so if it's convenient to the court, they could sit behind page 2470, because that's where paragraph 15 follows in sequence.
Okay.
The next is the EOG case. My lord, can I just suggest that goes at the back of the authorities bundle behind tab 60? It would be 61.
60.
Well, tab 60 should be a portion of the guidance and toolkit for impact assessment, so if it sits behind that, it would be effectively 61.
I haven't printed it out, the EOG case, and I didn't bring my laptop. Right, my time right. You've got a copy, I imagine.
Yes, we have.
Thank you.
Sorry, where did you say that should go?
Just at the back, right at the back of the authorities bundle.
Yeah.
And these came as an attachment to an email, didn't it?
They did, my
So
lord.
we've got it electronically.
Yes.
Yeah.
EOG, I haven't had it. My lord, there's then the first instance decision of the Federal Court of Australia, Australian Conservation Foundation Incorporated, and Minister for the Environment. And my lord, that should be at tab 56 of the authorities bundle.
Yes, I think we put that in yesterday, didn't we?
Right, yes. Yeah. And my lord, finally, there is the latest report to the World Heritage Committee and draft decision.
Yeah.
And can I suggest that that simply goes into the back of supplementary hearing bundle 3 as additional documents.
Yeah. So that's 46 yes?
Yes.
We already had 44 I think probably now everything is where it should be.
Hope so.
Thank you very much for that.
For the two documents I handed up. One is the summary of decisions of the previous two World Heritage Committees. I suggest that goes in the back of supplementary bundle 3, behind Learn and Friends document.
Yes, just
SB3. SB3.
SB3, my lord. Yes. So we've got that right at the back.
I'm just going to put SB3 question mark question mark. Have you got a tab number or anything for that?
Let's see if we can...
My lord, it would be tab 32 if 46 becomes 31, it would be tab 32.
Okay.
Thank you.
just a second. What's happened is that
And this document is different, is it? From 46com, the one that you're talking about now.
No, one, my lord, it's the document which the first page is 44com.
Yes, okay.
And then
Then 45 and
then 45com as we're treated as one document.
Page
Yeah,
3.
yeah.
We get to 45 column on page 3.
That's correct, my lord. On page 4.
Yeah.
That's
Yeah.
And that goes together with Court of Appeal skeleton, paragraph 42, 43.
Yeah. Well, that skeleton, my lord, the sensible thing is to slip it wherever my skeleton has gone, which in the core bundle is tab 4.
Yeah. Right. So you want to keep all of those materials together?
My lord, I'm happy for the World Heritage Committee record 44 and 45
Yeah.
Probably the sensible place to put that is right at the back of the supplementary bundle 3.
Yeah, that's where I
immediately
put it.
following on from, I think my learned friend says it will be tab 32.
Yeah.
Immediately following on from the other document we put in.
Yes, no, that's fine. I think that's. I'll just put a post-it on there.
31 or 32.
And then I'll put the other document with your skeleton argument. Thank you very much. Right, we're there. Right, yes.
My Lord, I'm grateful. My Lord, I'm dealing with the grounds which raise issues with regards to the World Heritage Convention and decisions of the World Heritage Committee. And my Lord, they are in two parts. First relates to the Minister's consideration of the risk that implementation of the scheme could lead to delisting was unlawful. And also I'll pick up under that ground the unlawful failure to have regard to the most recent decision of the World Heritage Committee. And so that is judicial review ground 3,
Yeah.
as well as ground 8 with regards to the failure to have regard to the committee decision. And it's appeal grounds 2 and 5. And it's paragraphs 98 to 116 of our Court of Appeal skeleton.
Sorry. Skeleton argument.
98 to 116, and as well as it's paragraph 43A as well, which is the failure to have regard to the World Heritage Committee decision. So that's the first ground I'll be addressing. The second, the unlawful approach of the Minister to the World Heritage Convention, and that's judicial review ground 4 and appeal ground 6, and it's paragraphs 118 to 136 of our appeal skeleton. And my Lords, before going on to address each of those grounds in sequence, there's an important part of the factual context which is relevant to both grounds, and that is the findings of the Secretary of State with regards to harm to the World Heritage Site. And it's necessary to deal with those in a little detail because it's not immediately clear from the decision letter itself. One has to have regard also to the examining authority's report and the High Court judgment. So if I could just take 10 minutes to explain that.
Of course, yes.
So my Lord, could I start please with the decision letter, which is at core hearing bundle. It's page 598.
Yeah. Yes.
And one sees paragraph 20. Paragraph 20 says, where not otherwise stated, the Secretary of State can be taken to agree with the examining authority's findings, conclusions and recommendations set out in the examining authority's report.
Yes.
So that's the first marker. If one then flicks forward to paragraph 82, which is on page 612, this is in the context of the Secretary of State's discussion of heritage impact. And you see at paragraph 82, ultimately, bottom half of the paragraph, the Secretary of State accepts that the adverse impacts from the Western Tunnel approach cutting and Portal, the Long Barrow Junction and the Eastern approach and Portal, on balance, when considering views of historic England, Wiltshire Council satisfied any harm to the World Heritage Site when considered as a whole would be less than substantial, and harm to the significance of heritage assets would be less than substantial, and therefore the adverse impact should be weighed against public benefits. And I'll come on to the policy test in a moment.
Yeah.
Those findings are essentially the same as what was found in the first decision letter, which was quashed by the High Court in the first judicial review. And if I could ask your Lordships to turn to the third volume of authorities,
Yeah.
tab 47, which is the first judicial review decision from the High Court. And it's page 1977.
Yeah.
And at paragraphs 142 to 144, perhaps if I could just ask the court to read those paragraphs. And
The sideline paragraph.
thank you.
Yeah.
So my Lord, the submission was made that how the decision letter should be understood is disagreeing with the categorisation of the level of harm, but not the reasoning with regards to the impact to the World Heritage Site. And so if I could then ask the court to turn to the examining authorities report, which is in supplementary hearing number 1, to look at what are the impacts.
Do you want us to keep Stonehenge 1 open or?
No, my Lord.
No, it's fine, okay.
Did you say SB1?
SB1, please, my Lord. Page 71.
Thank you.
So my Lord should have beginning of a discussion on the third main issue, which is spatial relations, visual relations and settings.
Yeah.
And one can see at paragraph 5.7206, the examining authority agrees that there would be certain benefits by removing part of the road from the vicinity of the stones. And I'll just ask you to scan that paragraph.
Yeah.
But then going over the page at 207, however, the examining authority has serious concerns regarding the effects of elements of the proposed development on the OUB of the WHS and on the cultural heritage of the historic environment of the wider area. These concerns relate to the western approach and cutting portal. So, my Lord, it's not simply, there was a discussion yesterday about the portal, it's of course the approach road, which is about 1 kilometre within the World Heritage Site.
Yes.
The proposed Long Barrow Junction, which sits outside of the World Heritage Site, adjacent to it, and then to a lesser extent, the eastern approach. And then if one goes just I'll just pick up a few references from the findings of the examining authority. 5.7.217, page 73. It starts to deal with the western cutting and portal. And the final sentence on that page, in the examining authority's view, this part of the World Heritage Site would be seriously disturbed by the intervention of the cutting and the western portal. And then at paragraph 225, well, in fact, 224, page 74, the examining authority accepts that much harm arises from existing roads, but makes the point that these roads could be removed at any time should a satisfactory scheme be put forward, just as the A344 was removed, leaving little permanent effect on the cultural heritage of the Stonehenge landscape. And then, on the other hand, the current proposal for cutting would introduce a greater physical change to the Stonehenge landscape than has occurred in 6,000 years. It would be permanent and irreversible. One then finds discussion of the attributes of 227, 228 and 229. And if I could just ask your lordship to scan those.
227, did you say?
Yes, 227 to 229, my lord. Then moving on to page 77, in a discussion on Long Barrow Junction, paragraph 243, making a point about the particular size of this junction, from above dwarfing all other individual features, including the stones. And then at paragraph 245, final sentence, the junction would have effects on the OUB similar to those described for the cutting and western portal. And then, my lord, flicking forward to page 87. Here the examining authority dealt with the OUV and historic environment as a whole, and it went through each of the attributes. And if I could ask your lordships just to read 307 to 313.
Is this, forgive me, is this a rationality challenge to what's said in DL 20 and 82?
No, my lord, but it's the context.
Or are you just re-arguing the merits?
No, not at all, my lord. These are the findings of the Secretary of State, and that's the context. And why this is important, the grounds I'm about to argue, is that these are findings the Secretary of State agreed with.
Yeah.
The Secretary of State considered there was no breach of the World Heritage Convention. My lord, this is the harm that we are talking about when we come to look at the World Heritage Convention.
Right.
And it's also, my lord, goes to the issue of the risk of delisting, because my learned friends for the Respondent seek to downplay the potential risk. But
So is this a rationality challenge to giving no weight to the risk?
yes, that was one ground, yes. But this is the factual context.
Yeah.
To make clear to the court that these are the findings of the Secretary of State. And it's really to meet the response, which is to downplay that risk. But I say, my lords, having regard to what the Secretary of State, what the Minister himself found, it can't be said that there is simply no possibility. So that's really the purpose of this exercise, and because it's not clear from the decision letter itself, it has to be read together with this. And then over the page, my lord, just finish this off at 3.315 on page 88. With regards to integrity, irreparable spatial division and harming understanding into the World Heritage Site. Serious harm to authenticity at 319 to 320. And then at 321, permanent irreversible harm critical to OUV would also occur. The overall effect on WHS OUV would be significantly adverse. So none of those findings have got anything to do with the substantial or less than substantial harm test in the NPSNN. Those are the impacts which Mr Justice Holgate found in line with the submission of the Secretary of State. The Secretary of State had found. I hope that's clear. So that is the context, and if I can then move on to the...
I'm sorry, I'm being slow.
Yeah.
The connection to the Secretary of State's thinking is...
My Lord, so DL20,
Yeah.
the Secretary of State adopted the examining authority's findings unless otherwise...
Where not otherwise stated, the
Not where
Secretary
not
of State
otherwise stated.
to be taken to agree with the findings, conclusions and recommendations. So that's a general statement, and he's therefore setting up for himself the task of identifying where he doesn't.
Exactly. And, my Lord, an issue was exactly the same findings were made here as in the first JR, in terms of was it substantial or less than substantial harm. And that's why, so the Secretary of State then had to explain his decision to the court and said how it has to be read as I've simply disagreed with where the examining authority says substantial harm. I consider it's less than substantial. But every other finding I agree with, and that's why I took your lordships to a portion of Mr Justice Holgate's judgment.
So that what this turns on is a disagreement between the Secretary of State and the examining authority about whether it's substantial or
Exactly.
less.
It's categorisation for the purposes of the policy as opposed to impacts of the scheme, and that was very clearly submitted by the Secretary of State to the High Court and accepted by Mr Justice Holgate.
All right.
So, my Lord, if I could turn on to the issue of delisting and being placed on the list of World Heritage and Danger. My Lord, there are three aspects to this ground. The first is that the Minister was not informed and therefore did not take into account the latest decision of the World Heritage Committee, which was that if the scheme went ahead, the scheme would warrant Stonehenge being listed on the list of World Heritage and Danger. The second point is, having decided not to rule out the risk of delisting, it was irrational not to consider the consequences or the effects of delisting.
Okay.
And the third...
Sorry,
Hold on.
Sorry.
you're going very fast.
Not informed of the latest decision of the WHC that the proposal would warrant listing on the danger list I've written down,
Yes.
I know what it means, and then not ruling.
Having decided not to rule out the risk of delisting, I'll come on to expand on these in a moment, it was irrational...
Hold on.
Sorry, you need to take these more slowly.
Yes, of course, my Lord. I've written them at paragraph 98 of our skeleton.
Right, what would you like us to do?
I'm just simply introducing the points.
All right, so would you like us to look at paragraph 98?
Yes, it would probably be convenient for your lordship's note. That's where they've been set out.
Right, so paragraph 98. Yes, so it's those 3 points.
Those 3 points. So, my Lord, I'll order my submissions as follows. First, I'll take the lordships to the World Heritage Convention and operational guidelines, in particular to explain the list of World Heritage in danger and the process of delisting. Second, I'll take your lordships to what representations were made during the redetermination process. Third, I'll address briefing to the Minister. Fourth, address why the reasoning in the decision letter was unlawful, and then I'll address the decision of Mr Justice Holgate.
Right.
Could you, for my benefit, just in case I'm missing, could you formulate what is the significance of delisting in the context of this litigation? Because at one level, there may be scope for, you might concede, I don't know, but there may be scope for a lawful decision to do something which would lead to delisting.
Yes.
What I'm not, I think, clear about is what is it about delisting that makes it a relevant consideration for the Secretary of State taking this decision?
Well, the World Heritage Site is a creature of the World Heritage Convention, so its status comes from its listing under the World Heritage Convention.
Yes.
So if it were to be delisted, it would be a loss of status, loss of its World Heritage.
Well, in many aspects of life, status is regarded as something ephemeral and something which one shouldn't be too worried about. What are the practical consequences
I was going to take
for Stonehenge?
Well, the practical consequence of being on the list of World Heritage in Danger is being subject to annual review by the World Heritage Committee. Annual review by the World Heritage Committee in terms of submission of reports. The consequence, well, as was highlighted by the Stonehenge Alliance, would be national embarrassment for the UK. It would be potential loss of revenue from visitors. It is the emblematic World Heritage Site. I mean, my lord, that is it in a nutshell. I mean, I'll take your lordship's
embarrassment that we've contravened something which we said we would try not to contravene, or which we've signed up to, and loss of visitors, because fewer visitors may come if it's not a World Heritage Site.
Yeah, may I take your lordship to how it was
Yes.
put?
I'm not being sceptical.
No,
I just want to be entirely
no,
clear.
but that's it.
I just wonder whether we oughtn't to look at what the Secretary of State says.
Yes.
Because the question is whether the Secretary of State has acted unlawfully. So if you look at the convention and the arguments and so on, the danger is we'll be dragged into a decision. Well, do we think that's a good thing or a bad thing? Because what we really need to do is identify the decision paragraphs and then see if they're lawful. But I don't want to take you out of your.
I stand correct.
If it would be helpful, yes, we can look at the paragraph first, and that's in the decision letter.
I mean, it seems to start at 95, and then there are various references to the mission report in April and the final report, and you're hinting that there's been a decision that came after the things referred to, but before the decision.
Sorry, my lord, I was going to start with the decision letter of the Secretary of State.
That's what I mean.
Yes.
Well, let's just listen to what you say about the decision letter first of all,
Yes.
and then we'll
So,
go from there.
decision letter at page 619 of the core bundle. And this is the paragraph of reasoning.
So paragraph.
So, sorry, it's the final bullet point on page 619.
Right, so we're in paragraph 101,
Yes.
final bullet point.
So, well, that is the paragraph we are concerned with. So the Secretary of State accepted that was a material consideration, but gave no weight to it. As I'm going to explain, that paragraph was in ignorance of the fact of the latest World Heritage Committee decision. And in order to explain the significance of that, I do need to take your lordships to the Convention and Operational Guidelines to explain why it was obviously material to this issue.
And can you give us the date of the decision, please? You say the latest decision.
The latest decision before the Secretary of State's decision which was July 2021. Apologies, my lord.
Right, okay.
Right.
So if I could ask your lordships to take the third volume of authorities.
Yeah.
Tab 57.
That is the convention.
This is the
Page,
convention.
page.
Page 2448.
Thank you.
Article 11. So Article 11.1 is each state party shall submit to the World Heritage Committee an inventory of property forming part of the cultural and natural heritage in articles, sorry, provided for in paragraph 2 of the article, which is the World Heritage List. So what happens is each state party puts forward the sites that it considers to be part of World Heritage, i.e. World Heritage sites or World Heritage properties, and then the committee decides whether it should be included on the World Heritage List. And then paragraph 4 deals with the list of World Heritage in danger. Just ask your lordships to scan paragraph 4.
Yes.
And then at paragraph 5 simply says the committee shall define the criteria on the basis of which the properties will be entered into the list. One turns to tab 58, which is the operational guidelines, and on page 2469.
I'm sorry, the builders just clobbered that last reference.
2469.
2469.
And what's the status of this document?
So the operational guidelines at paragraph 1 are for the implementation of the convention. And one can see at paragraph 2 they're periodically revised to reflect the decisions of the World Heritage Committee.
So it's procedures for setting the various things there,
Yes.
and they're revised.
Yes.
Right.
So turning to paragraph 77 on page 2471, just so your lordships note, there's there the criteria for how outstanding universal value is to be ascertained. And then one can see at paragraph 78, to be deemed of outstanding universal value, the property must also meet conditions of integrity and or authenticity and have an adequate protection management system to ensure safeguarding. And again, the need for integrity is repeated at paragraph 87 on page 2.73.
Integrity is a concept that may be capable of different meanings in different contexts.
Yes, absolutely.
I mean, there's physical integrity, there's also aesthetic integrity,
Yes.
maybe other kinds of integrity.
Yes. Yes. If one then turns on to deal with the list of World Heritage in danger,
Yeah.
it starts at page 177.
Sorry.
Sorry, paragraph 177, page 2479. You can see the criteria. The property must be on the World Heritage List. threatened by a serious and specific danger, major operations are necessary for the conservation of the property, and assistance under the convention has been requested for the property. And one can see it, assistance can be requested by any committee member or the Secretariat.
These are the considerations for
the list for being placed on the list of World Heritage in danger.
Yeah. Are there other factors identified as being factors that would cause such a decision to be necessary or appropriate? In other words, threshold considerations. I mean, these are the considerations for actually delisting.
Yeah. No. For being on the list of World Heritage in danger.
Sorry, for putting on the list in danger. Are there? What I'm asking is, are there prior criteria for undertaking that exercise?
No, my lord. There is. So there's some further explanation at 178.
Yeah.
So one can see at 179 in the case of cultural properties, which Stonehenge is. One can see a potential danger at the properties faced with threats which could have deleterious effects on its inherent characteristics. Such threats are, for example, the Roman IV threatening effects of town planning. And then at paragraph 181, it makes clear that the threats or their detrimental impacts on the integrity of the property must be those which are amenable to correction by human action. And one can see at the bottom of that paragraph, in some cases, the threats or detrimental impacts may be corrected by administrative or legislative action, such as cancelling of a major public works project. And then, well, dealing with deletion, or first,
and
sorry.
182 says there are other considerations that they may want to take into account.
Yes, ma'am.
Yeah. And these are all matters for the committee to consider,
Yes,
are they?
Yes.
Are you going to show us the procedure, or?
Yes, the procedure. Well, the procedure starts at paragraph 183 to 189, and one can see that the at 186, a decision has to be taken by a majority of 2/3 of committee members present and voting. And then at paragraph 190 and 191, one has the consequence of being on the list of World Heritage in danger for the purposes of the convention.
And looking at 185, the state party has the opportunity to comment, does it?
Yes, it does, Lord.
Right.
And then, my lord, at 190 and 191 is the consequence of being on the list of World Heritage in danger. So it's at 190 an annual review, such monitoring procedures and expert missions as might be determined necessary by the committee. And then on the basis of the regular reviews, the committee shall decide, in consultation with the state party, whether additional measures are required to conserve the property, delete the property from the list of World Heritage in danger if the property is no longer under threat, or consider deletion of the property from both the list of World Heritage in danger and the World Heritage list if the property has deteriorated to the extent it's lost those characteristics which determined its inscription on the World Heritage list in accordance with the procedure, which is then set out below in this procedure in paragraphs 192 to 198.
Yeah.
So, my lord, drawing that all together, the placement of a World Heritage site on the list of World Heritage in danger or delisting is a matter for the World Heritage Committee. It is not coterminous with whether there's a breach of Articles 4 and 5 of the World Heritage Convention. That's a separate ground, and I'm going to come on to that. Deletion.
Sorry, not coterminous.
It's not coterminous with a breach of Articles 4 and 5.
Have you got at your very fingertips the reference for Arts Form 5?
I have. It's AB Authorities Bundle 57, and it's 2445.
2445. Thank you.
Deletion is not an inevitable step after being placed on the list of World Heritage in danger, but it is a potential next step. And the fourth point is that a World Heritage Site cannot be deleted from the World Heritage list on the basis of a threat. So prior to a road scheme going ahead, there would not be deletion of the World Heritage Site because the damage hasn't occurred. So the fact that the World Heritage Site has not been delisted, we say is wholly irrelevant to this ground. So if I could then turn to the decision of the World Heritage Committee.
This is the last decision which he wasn't told about.
Yes, exactly.
Thank you.
And it's Supplementary Hearing Bundle 3, page 243.
228?
243.
243. I'm very sorry, my hearing is not very good.
Sorry, my lord, my projection. 243.
Thank you.
Yes.
So, my lord, you can see it, paragraph 7, there's a reiteration of concern. And the World Heritage Committee had, on numerous occasions, raised concern about the scheme. You can see that reference to paragraph 7. Paragraph 8, it notes with concern the decision that a longer tunnel would not justify the cost. Reiterates at paragraph 9 its previous request that the scheme should not proceed. Paragraph 10 notes commitment to ongoing engagement. It says unclear what might be achieved with further engagement unless the design is fundamentally amended. And then at paragraph 11, regrets that DCO has been granted for the scheme and notes that it is a potential threat to the property which, if implemented, could have deleterious effects on its inherent characteristics, notably to its integrity. And then at 12, in the event the DCO consent is confirmed by the High Court, the property warrants inscription on the list of World Heritage in danger.
And the date, I can't actually see the date.
No, my lord, it's July. It's July 2021. Don't have an exact date, but and the High Court decision was the 30th of July 2021.
Yeah, so sometime in July.
So, yes.
And does this reflect previous decisions? Was there any material change between this decision and the earlier one?
So this was the first time the World Heritage Committee had said that the scheme warrants the World Heritage Site being placed on the list of World Heritage in danger. So that was entirely new.
Which paragraph is that again?
So that's paragraph 12. 11 and 12, they have to be read together. And 13.
So those three paragraphs
Yeah.
were entirely new.
Entirely new. My lord, if I can deal with what the parties said about this. So at page 35 of this supplementary hearing manual.
Right. Just
Volume 1.
Volume 3.
Volume 3, page
35. Apologies, 34. So Historic England highlighted a separate report which had been made to the World Heritage Committee called the State of Conservation. And I don't know if I need to go, given the time, I need to come back to that and reply if it's relied upon, but it wasn't drawn to the Secretary of State's attention.
Right, so what specifically on 34?
It's 6.5
Yeah.
Historic England of the opinion that the World Heritage Committee decision should be a material consideration in the Secretary of State's redetermination.
Right, so 6.3, I know you say this wasn't drawn to his attention, but to get the fact, 6.3, had anyone read it, would say what this decision was that we've just looked at. And then 6.5 gives the opinion of Historic England on it.
So what it does, my Lord, is it draws attention to a report made by the UK to the World Heritage Committee called the Stated Conservation Report. The Stated Conservation Report continues to maintain that the scheme is beneficial for the World Heritage Site. It's a head in the sand report. It doesn't engage with the
No, I
findings.
understand that. I just want the facts, actually,
Yes.
rather than a description of the greatest respect.
Yeah.
So 6.3, is that a paragraph referring to the decision that we've
Yes.
just looked at?
The first part of 6.3
Does,
is the
yeah.
decision. It's the second. Sorry, I was looking at the second half.
Yeah.
Of 6.3.
And it's 6.4, 6.5 is Historic England's response.
6.5 is that it should be a material consideration. 6.4 is the Historic England drawing attention to that state of conservation report, which is a separate document.
And this went to the officials, presumably, but you say not to the Secretary of State.
Exactly. National Highways, in fact, actually, while we're in that bundle, ICOMOS UK, who are the National Committee of the International Council of Monuments and Sites, page 27 of that bundle.
Sorry, reference again
Page 27,
of this bundle.
yes.
Thank you.
And one can see, if I could ask, if there's any other matters arising since 12th of November?
Yeah.
If I could just ask your lordships to read those paragraphs.
Does it end at the bottom of page, internal page 3? Page?
That point, yes, that point ends.
Okay.
The document did go on.
And just for completeness, so we understand it, did this document get sent as part of the Rule 20 comments or not?
Did it get sent
As part of the Rule 20
as part of the
representation?
redetermination? Yes.
It did. So it went to the department.
Went to the department, yeah.
Yeah.
And then volume 3, sorry, volume 2, my National Highways.
Yeah.
Page,
153.
thank you.
My lord, this was dealt with by National Highways on 153 to 159, and of course, in view of the time, if I could ask your lordships possibly to read that at your leisure, but one can see it 1.2.17, which is on page 159. 1.2.17. Whilst we expect that the Secretary of State will take the World Heritage Committee decision into account in his redetermination, then it had explained why they considered it didn't affect the case for the scheme. And of course, National Highways was still maintaining that its scheme is beneficial for the World Heritage Site.
Can we just go back to 156?
156.
Top where
Sorry, Sorry, which paragraph?
The very top line, quote the decision.
And then Malone's friends asked to highlight that the decision was quoted.
At 156.
Oh, at 156.
Right.
And then, my lord, 294. Sorry. Apologies, I've got the wrong. Yes, 294.
2294.
2294 Stonehenge Alliance. It had previously drawn attention to the decision in an earlier representation.
Paragraph.
3.22.
Thank you.
And here it's really drawing the attention to that. Well, look, if cost is going to play a significant role in the decision-making process, one needs to consider the value of the World Heritage Site. Not only, sorry, just ask your lordships to have regard to that paragraph.
So this document is Stonehenge Alliance.
The Stonehenge Alliance, my lord, it's August 2022. So, my lord, none of those submissions were drawn to the attention of the Secretary of State.
Well, can I just check then? I mean, we accept it's gone to the department, and we don't want to go back over yesterday what goes to the department and what must go physically or electronically to the Minister. But the opening words of the bullet point says several respondents, including the Stonehenge Alliance, the consortium of Stonehenge experts, and ICOMOS, the one we just looked at, refer to the World Heritage Committee power to delist properties and refer to the prospect of Stonehenge losing its status. Isn't that telling the Minister, look, people are concerned, it might be delisted?
Yes, my lord, but what the Minister is not told is that the World Heritage Committee has taken a decision that this warrants being placed on the list of World Heritage in danger. And if one is assessing risk of delisting, that is clearly highly material to the level of risk.
It's not told that they warrant placing on the danger list, I'll call it. Yeah.
Yes, my lord.
Not told that consideration was being given, I think.
Sorry, my lord.
They were not told that consideration was being given to that delisting.
But I think it's just more simple than that, isn't it? Your submission is they were not told of the July 2021 decision. Full stop.
Yeah. But, and I needed to explain why that was important in relation to the issue of delisting, because it is a potential first step.
Yeah.
So well, that's the first point as to why the Secretary of State's decision was unlawful, and then just addressing the reasoning, and it might help for the court to have the paragraph in front of it.
We're putting those materials away now, are we?
Yes, my lord. Yes.
All right, just a second.
Turning back to paragraph 101 of the decision letter.
All right, just a second, thank you. Yes.
It says that no wait, because if it were to happen, it would happen as part of a separate process, satisfied the decisions in accordance with the policy, not lead to the UK being breach of the World Heritage Convention obligations, and the applicant would be working with advisory bodies. Now, my lord, we say those are first, he hasn't ruled out the risk of delisting, and therefore so it's irrational not to consider the consequences. But in terms of the reasoning, we say that was equally irrational. The fact that it will happen as part of a separate process cannot rationally be a reason to give no weight to it.
That's a prior point, isn't it?
Sorry, my lord?
It's a prior point. It's the other way around. The first question should be whether it's irrational to just put it on one side because it's part of a separate process. And as I understand your submission, you say the July decision goes far enough down the route to make it, to create a risk, even if someone else is driving the process. Only if that is irrational does it become irrational not to consider the consequences. Because if it's not irrational to put it on one side altogether, then you can't have a freestanding point of should have considered the consequences.
Well, except I suppose when the risk hasn't been entirely ruled out. So even irrespective of that decision, the Secretary of State hasn't ruled out the risk.
Thank you.
But my lord, the decision is of course relevant to this because of course the decision of the World Heritage Committee directly links. It's this decision on the road scheme which would lead to being put on the list of World Heritage in danger. So that's the link. So it may happen as part of a separate process, but it's the Secretary of State's decision which will cause that process to occur.
There'll be two stages, won't there? First, the stage we've got to at the moment is the risk of it going on the list of properties in danger.
Yes.
And then you say, should the development actually occur, and should the road and the tunnels and everything else be built, that may lead to a second decision, the decision to delist.
Yes. My lord, the second reason about being in accordance with World Heritage obligations, I'm going to come on to that under the next round, but as your lordship saw, being in accordance with Articles 4 and 5 has got nothing to do actually with being delisted.
But it's an odd thing, it's not an obligation like the Genocide Convention, which says you mustn't have genocide. Or is there an obligation saying you must not do something that will threaten? There is.
My lord,
As opposed to, it would be very unwise of us to do this for all the reasons you've given about visitor decline, national embarrassment and so on.
My lord, I'll come up because it's a
You come on to that when you
separate
do the
point, but
treaty, yeah.
Yes.
Can I, sorry to bring us back, you've probably shown us what the judge in the court below said about this. Can we just remind ourselves?
Yes. So it's CHB Court Hearing Bundle 1, page 215.
Yeah.
So my lord, Judge below didn't deal with the fact that the decision, so the decision is mentioned at page, paragraph 210. My lord didn't expressly agree, deal with the point about it being a obviously material consideration for the Secretary of State. And then with regards to the reasoning, so paragraph 217, we say to the extent that the factors listed there affected the judge's reasoning.
You mean paragraph 217?
217.
Yeah, that's on page 220.
220. So it's correct that the World Heritage Committee didn't have the same evidence, but we say that I don't see the relevance here. It's not a point that the Secretary of State took into account. It's correct that the World Heritage Site is not on the list of World Heritage in danger, but the decision of the committee was very much dependent on what the High Court was going to do. And the decision was then quashed, so we would say, well, of course it wasn't on the list of World Heritage in danger. And then it's correct that the World Heritage Committee hasn't determined that it would be removed. But of course, as I've shown the court, for deletion, then must have been, the impact must have occurred.
It's paragraph 218, isn't it?
Yes, my lord. So that was doing 217,
Yeah.
218.
Well, it's in 218 that Mr Justice Holgate deals with the rationality or otherwise of giving no weight to the risk of delisting. As we've seen, he says, any question of delisting would be a separate process in which the key issue in the discussion would be whether Stonehenge has lost those characteristics of AUD.
Well, that fails to acknowledge, one, the link between this decision the Secretary of State for Transport is taking and the World Heritage Committee's decision.
Are you saying anything more complicated than, given the material that should have been in front of the Secretary of State, that it was or wasn't, he should have appreciated that going ahead with this scheme gave rise to a real risk of delisting?
So what we're saying, first, that material should have been taken into account when he calculated the risk. And the risk,
Yeah,
of course...
but for these purposes, I'm accepting that. Given the material which you say should have been before the Secretary of State, he should have appreciated that there was at least a risk, even if the risk was driven by other people, and that should have been a material consideration.
I would say I don't need to go that far, because that's a Section 31 point. I suppose if it said against me, this could make no difference, then yes, I would say this could clearly have made a difference to the Secretary of State's decision, if he had taken into account.
No, I'm not clear what the problem is. I've understood through all of yesterday that you have major concerns about the procedure by which this decision was reached.
Yes.
I understand, although there's things that seem to conflict what you told us this morning in the judgment, that the material went to the department and you say that's not enough. By physical or electronic means it must have crossed the Minister's desk and it didn't. And therefore I understand your procedural argument that there has been a failure to address this. I've got that point,
yes.
So I'm putting that point to one side now.
Yes.
I'm asking myself now a separate question under the heading question 2. If I don't accept what you say on that, or if you win on that and I don't need to get to question 2, so be it. What are you saying about the fact that the committee could consider and was considering the possibility of putting it on the list, and the decision of the judge and the Secretary of State?
So you're saying failure to take into account.
Yeah, we've done that
The material,
to death.
but as a mandatory material consideration,
Yeah.
as opposed to simply irrelevant or important. We do say this is a mandatory.
Yeah, I've got that. The one that it didn't go there, and two,
that the reason
that it should have gone there, even if we don't accept what Mr Wood said yesterday, because it was not mandatory. And I try to encourage you not to repeat procedural points and to tell me whether there's anything else or whether just tell me, so I've got it, that it is just those 2 points.
The reasoning was irrational.
Right. And why then?
Because set against a decision, set against an understanding of the process by which this occurs in the World Heritage Committee. Yes, it's a separate process, but it's one that the Secretary of State doesn't control, and there was an immediate link between his decision and the process that the World Heritage Committee was undertaking. And the Secretary of State then went on to say, well, I'm satisfied it's in compliance with policy. Well, all that means is that the benefits outweigh the harms in his view. Again, that has no... Sorry, Miller.
So it's irrational for him to say, this is a process, the committee, the consideration, the criteria, and I'll deal with that and try and persuade them that even if this scheme is adopted, it's not lost its fundamental characteristics, however you want to put it. It's irrational for the Secretary of State to do anything other than say, there is that risk, I shan't run it.
Well, My Lord, first, that's not what the Secretary of State said. All he said was it would happen. It would happen as part. Sorry, if it happened, it would happen as part of the separate process.
Yes, I know the words he used, but we've just looked at the process, and you very helpfully took us through the guidelines and their criteria, the state parties involved, and so on. So what the Secretary of State must be saying is he thinks that in that process, it won't, or he'll be able to persuade them not to delist.
Well,
and you're saying it's irrational, are you,
yes,
to take the risk?
No, my Lord, I'm saying that the reasoning given is irrational to give that factor no weight.
You're saying, aren't you, I think, that I'll add words for the sake of emphasis only, not for any other purpose, that the mere fact that it was a separate process was not of itself
Eliminate the risk.
a rational reason for not taking into account the risk. And I'm again supplying words, that if I make this decision and the road is built, it is significantly more likely that Stonehenge WHS will be delisted. To say that that's a separate process is not of itself and by itself a rational reason for reaching that conclusion, is what you're saying.
Yes. My Lord.
And I don't think it really gets any more complicated than
I
that.
don't think it gets more complicated. My Lord, I'm very conscious of the time right now. I have to deal with a very next complicated ground.
All right. So have we? I've cut across my.
No, that answers it.
Lord.
I understand
Yeah.
the three ways in which you now put it. The information did not go. On any analysis, it should have gone as a mandatory consideration, and the reasonings are rational, the reasons that my Lord has just outlined, that the fact that he's got the chance to persuade them not to isn't an answer to the fact that there might be a greater risk if he goes down literally this road.
My Lord, yes, and I don't accept that. The fact that there's a chance to persuade the committee can be read
Yes.
into the decision.
I've got that, yes.
My Lord, if I can then
Thank you.
move on to the World Heritage Convention.
Yes, just to tie this back to the grounds again.
Yes, my Lord. So it's JR Ground 4,
Thank you.
Appeal Ground 6. And it's the lawfulness of the approach to the World Heritage Convention. And in short, Appellant's case is that the court should decide the interpretation of the convention, and the test is not one of tenability, but even if it is a test of tenability, then the minister's approach was untenable. So, my Lord, I'll deal with first what the Secretary of State found with regards to the convention, go to the legal context, and then go to the policy test and the convention tests, and then pick up the judgment of Mr Justice Holgate.
Right.
Look, the findings on the World Heritage Convention start with the examining authorities report at Supplementary Hearing Bundle 3, page 278.
278.
Yes, my Lord. So it's the portion from 7.3.35 through to 7.3.43. And in short, as one can see at 7.3.39, the examining authority found that the UK had taken the steps required by Articles 4 and 5 by putting in place a legal and policy framework in connection with consideration of harm. And that's in the NPSNN and NPPF, and therefore the protection is integrated into the planning system. Then found that because if the scheme complied with the NPSNN, it would effectively comply with the convention. And one can see that at 7.3.43. turning to the decision letter, which is a core hearing bundle 638. So it's 638. And you can see at paragraphs 185 through to 187, the Secretary of State agreed with the examining authority effectively that it was the MPSNN had complied with the World Heritage Convention, and therefore effectively the planning balance in the MPSNN would determine whether the UK was in breach of its obligations, and one sees that at 187.
So you, the paragraphs you wanted to...
185 to 187.
Thank you.
Does this grant have crossover to the last grant?
No, my lord, they are different points.
They are different
and
points.
they're related.
If the Secretary of State's view is tenable and tenable is the right test, how does that impact on the attitude that the Secretary of State should have to risk of delisting?
It doesn't, my lord, because Articles 4 and 5 aren't part of the test for whether the site would be delisted or not.
Okay, thank you.
If I could turn to the authorities bundle, so the Planning Act at tab 2, on page 63. Here's where the domestic obligation arises. So subsection 3 of section 104 is a requirement to decide in accordance with the national policy statement, except to the extent that one or more of subsections 4 to 8 applies. Mr Wolf took the court through some of those sections yesterday. And if I can make 5 points on this statute. First point is that all of the parties agree that Articles 4 and 5 are international obligations for the purposes of section 104.4. The second point is that it's an obvious one, but it's the obligation on the Secretary of State to consider the World Heritage Convention is a domestic law obligation. And this is the obligation which gives rise to the public law point in these proceedings.
The obligation to consider
The World Heritage Convention.
is a domestic obligation.
Yeah, and it's this section that gives rise to the public law point in these proceedings. I say it's relevant when I come on to the case law in a moment.
There's a domestic obligation by virtue of section 104.
Yes.
Yeah.
1044.
1044.
Yeah. The third point is just because it is a discretion on the Secretary of State to decide whether the application is in accordance with international obligations does not mean it is not for the court to determine the interpretation of those obligations. So I seek to draw a distinction between application and interpretation. And in that regard, I would draw the court's attention to subsections 5 and 6 as well, because those are where the Secretary of State is satisfied there being a breach under any duty or under an enactment or unlawful by virtue of any enactment.
5 and 6 as well.
5 and 6. So it's the same principle there. It is for the Secretary of State to determine whether the act would be in breach of a duty, the application. But I say in those sections it would also be for the court to determine.
Yeah. Are these 5 points, incidentally, in your skeleton argument?
No, my lord, they're not.
Right.
That was number 3.
That was number 3. They're not certainly in this format.
Yeah.
Okay.
The fourth point is that whilst the statutory provision does not expressly require the Secretary of State to refuse an application, this is in response to points made against me,
Sorry, whilst the statutory provision does not
require this, so the Secretary of State could find a breach of an international obligation and yet approve the scheme.
That's Mr Wolf's point yesterday, that it tends in that direction.
But there's a clear steer.
It tends in that
Yes,
direction.
exactly. So that's that point.
Can I just get this down? Whilst the statutory provision does not require... Can you complete the
Yes,
proposition?
whilst it does not require dismissal of the application where there is a breach of an international obligation. There is a clear steer in those subsections, when read as a whole, that these are circumstances in which an application would be refused. And I don't actually put much store by that.
Because clear steer is a bit uncertain.
Yes.
We don't normally say things are unlawful because it's contrary to
No.
clear steer.
No, my lord. We absolutely accept that it is open for the Secretary of State to find a breach of the World Heritage Convention up front, nonetheless. But it's just simply looking at how this section is set out.
When the section as a matter of law says he doesn't have to decide in accordance
Yes.
with the policy if he's satisfied
Yes.
that it would lead to a breach.
Yes.
So that's the test really. So I'm not sure the clear steer helps.
Okay.
Yeah. Anyway, so that's point 5.
Four.
And
Point 4, yes.
yes. The fifth point is that the statute expressly envisages that there will be situations where there is a breach of international obligations, but accordance with the NPSNN. So the national policy statements, which are creatures of this statute, are not dispositive necessarily of international obligations.
Situations where there can be a breach of the obligations, but compliance. Can you articulate it again?
Yes, there will be situations where there are breaches of international obligations.
Yeah.
But compliance with national policy statements.
Yeah.
And so national policy statements are not dispositive of international obligations necessarily.
Right.
It's the same as 4, to
Sorry.
my way of thinking.
Could I, just for my benefit and perhaps for others, can I just run through,
Yes.
since they're not in your skeleton, I think I'd just really like to make sure I've got
Yes.
these down properly. I don't pretend that the language is exactly as you spelled it out. First point, all parties agree that Articles 4 and 5 are international obligations.
Yes.
Yeah. Second point, obligation to consider the World Heritage Convention is a domestic obligation. This, to which this section gives rise.
Yeah.
Section 104(4), that is.
Yes.
Third point, just because the obligation
Because it is a
Just
discretion.
because it's a discretion on the
Discretion.
Secretary of State to decide.
That does not
it's
mean the court cannot interfere.
to interpret.
is a discretion, does not mean that it is not for the court.
Sorry, double negative.
That's all right. They're quite respectable in English, as far as I'm concerned. Does not mean not for the court to interpret 5 and 6 also in the same case.
Yes. just drawing an analogy with 5 and 6.
Oh, I'm not seeking to reproduce the elegance of your articulation, but I just want to get the points down. 4. Whilst the statutory provision does not require the dismissal of the application, but as a breach of the international obligation, there is a clear steer in those subsections that these are circumstances in which, and I lost you,
an application would be refused or may be refused.
Would or may.
Or should be refused. I
would
think you're
or
saying.
may be refused.
Would, should or may?
It's well, legally, it may be granted.
No, but your clear steer is
Yes.
what? That it may, should or would be refused.
That it may be refused.
Yeah. And then fifthly, the statute expressly envisages situations where a breach of obligations occurs, but there is nevertheless compliance with national policy statements. So in those circumstances, the national policy statement is not necessarily dispositive.
Yes.
Right, okay, I think I've got the points.
Thank you, my lord. And if I could come on then to the case law, I'll try and
Right, is it?
take
No,
this.
and if I know you've several times said, bearing in mind the time,
Yes, my lord.
that's fine. Thank you. If you think it's appropriate, you could just give us the references, and we will undertake to read them carefully. If that's going to help you.
I think that I'd be very grateful for that.
Fine.
So there are 4 domestic authorities, and perhaps if I could take the court to the EOG case at the end, because that's the case that's come in and it's not dealt with. The first authority is Carriageway and Embassy of the Republic of Sudan, and that's volume 2 of the authorities bundle, tab 31.
I just want to get
Yes.
the spelling right.
BEKHAR.
Yeah.
It was an employment claim brought by a domestic worker in the Sudanese embassy, and the question was whether diplomatic immunity would cover the embassy. And the issue, there was an issue about whether Section 16 of the State Immunity Act was incompatible with the Article 6 of the ECHR. And as part of that discussion and the issue of customary international law, Lord Sumption at paragraph 35 gave a summary of circumstances where the United Kingdom should, where the court should limit itself to a tenable view. And he gave 3 examples whether it would impede executive conduct of foreign relations, or no one is asserting that here. 2, the rationality of a public authority's view on a difficult question of international law, for example in Corner House, and I'll come to that in a moment. And 3, where it's an issue where only a consensus of states can resolve. But then he went on at the end of that paragraph to say, I decline to treat those examples as pointing to a more general rule that the English court should not determine a point of customary international law, then tenability, which is dealing with custom at the moment. And he then said, if it is necessary to decide a point of international law in order to resolve a justiciable issue, and there is an ascertainable answer, then the court is bound to supply that answer. Just to highlight that.
You said paragraph 31.
Yes.
35, you
Sorry,
said.
apologies, 35.
No, 35 you said.
Sorry.
The Corner House case is at tab 20 of the authorities bundle, and was maybe well familiar with it. But it was a situation where the Director for Public Prosecutions had decided to discontinue investigations into an arms contract between the UK and Saudi Arabia. And the Director had claimed he was acting in accordance with Article 5 of the OECD Convention. And an issue arose as to whether that belief that he was acting in accordance with Article 5 was justiciable. And Lord Bingham found the claimant's arguments problematic, and that's on page 643, paragraphs 43 to 46. But in particular, one of the points noted by Lord Bingham was that the OECD Convention has within itself a method of resolving disputes between the parties, and said it's for that reason that the national court should hesitate before undertaking a task of unilateral interpretation. But ultimately, the court found it unnecessary to resolve the issue because it found that the official would have acted anyway, even if he had known that he was acting contrary, or believed he was acting contrary to Article 5, and that's paragraph 47. So, my lord, we would say the facts in Corner House are very different to the ones we have here. There was no domestic legal obligation that the court was dealing with, like Section 1044, and the OECD Convention is different. My lord, in terms of Friends of the Earth, which is at AB 49, I'd simply ask the court to have a look at paragraph 50, 55.
Sorry, you mean 50 and 55?
50 and 55.
Yeah.
Really just to highlight there that the courts noted that there was no requirement in that case for the Secretary of State to have regard to the Paris Convention, but it was a factor that the Secretary of State had decided to take into account when approving investment in a liquefied natural gas project in Mozambique. And the court, it was a particular factor, was the fact that there was effectively no domestic legal obligation on the Secretary of State in relation to that. And my lord, also relevant is paragraphs 38 and 46, which made clear that even if one is looking at tenability, one has to understand the structure, basic structure of the convention. So if I could ask your lordship just to look at those in your at your leisure.
Don't say leisure.
Yes. And if I could ask the court to turn up the EOG case, which we put at the back of tab 60 of the authorities bundle. We'll just explain this because it's not dealt with in solution argument. This case involved two cases relating to foreign nationals who had entered the UK outside of the EU and argued that aspects of the Secretary of State's policy were not consistent with the Council of Europe Convention on Action Against Trafficking in Human Beings, or ECAT. And ECAT has not been incorporated into UK law, but it was government policy to give effect to that convention. And one can see at paragraph 17 of Lord Justice Underhill's decision.
Paragraph 18.
17 now.
Yeah.
So we can see there that there was a government choice to implement obligations through policy. And then an issue arose as to whether the interpretation of ECAT was justiciable or not. And one sees that at paragraph 31 of the decision, page 373. So you see at the bottom of the page, on the eve of the hearing of the appeal to this court, the Secretary of State asked permission to amend grounds in order to argue that the meaning of ECAT was not justiciable. Then Lord Justice Underhill went on to address the justiciability point, particularly citing the decision of Mr Justice Linden in KTT, which is one of the cases which was under appeal in this case, at paragraph 32. And one can see it, there's passage that is cited there, paragraph 36, starting between D and E, the critical point in the PK Garner line of cases is the source of public law obligation contended for was declared policy of defendant rather than ECAT itself. In each case, it was decided or conceded as a matter of fact. This was in fact developed defendant's policy in construction of this, what her policy document said. And it goes on to then, it was therefore permissible for the court to consider what the requirements of those articles were. And well, ultimately in this case, the court didn't decide the issue of justiciability, because as we can see at paragraph 33, the Secretary of State changed her position again. But Lord Justice Underhill at paragraph 34 said, we did not have to hear submissions on justiciability. I should say, however, I find Lyndon J's analysis convincing, and I entirely agree with his conclusions.
Forgive me for asking, but does assuming it's justiciable, does that answer the question whether tenable view or correct view is the test? Because you could say it's justiciable, but the standard is tenability.
Tenability.
Does the EOG deal with that?
My Lord, no, it doesn't, but of course it is dealing with whether there should be the court's interpretation of ECAT or tenable.
Yep.
So there may be a distinction to be drawn between justiciability and interpretation. But my Lord, in my submission, what one gets from the case law is that there's no general rule that the court will not only interpret a convention if it is incorporated. There's no general rule to that effect. The key issue is whether either per Bencar-Bush it's necessary to resolve a justiciable issue, or whether there is a domestic public law obligation which requires the court to interpret this national obligation. And we say there is that domestic obligation here in the form of 1044. So, if I could then turn to the policy tests before going on to what the Convention provides. And it's Supplementary Hearing Bundle 3, page 219.
Two,
219.
290.
219.
And what is this
So
document?
this is part of the National Policy Statement for
Oh,
National
right.
Networks. And this is the Historic Environment chapter. I'm turning
I must be in the wrong place.
Supplementary
Supplementary bundle
3,
3, page 219.
219. There should be Historic Environment, 2/3 of the way down the page.
Yes. Okay. Thank you.
So turning the page onto page 220, 5.123, we can see that scheduled World Heritage Sites are treated as part of the category of designated heritage assets. So they're treated alongside listed buildings and scheduled monuments, for example. When it comes to decision making, paragraph 5.131, there's indication that the more important the asset, the greater weight to the asset's conservation.
So where are you now? I missed that.
5.131.
1, 2.
So 231.
Yeah.
And then one has the tests which apply. And at 5.133, the test of substantial harm or total loss of significance, refuse consent unless necessary in order to deliver substantial public benefits that outweigh loss of harm, or alternatively those bullet points apply. And then at 5.134, where there's less than substantial harm to the significance of a designated heritage asset, harm is to be weighed against the public benefits of the proposal, including securing its optimum viable use. So the short point is that the NPSNN allows for the balancing of heritage harm against any other benefits. So that could be relieving traffic congestion, economic growth, any number of things. We say that's wholly contrary to the World Heritage Convention, which is at tab 57 of volume 3 of the authorities bundle.
So if 5133 is contrary, is a breach of the convention.
It's not dispositive. Because it allows the benefits, economic or otherwise, to outweigh the heritage harm, it does not reflect the terms of the World Heritage Convention. So it could be applied in a way that would be compatible, because of course one could refuse a proposal. Under
133 does not reflect in wording the obligations in the convention.
Yes. Sorry, I used use language there, but that's what I meant.
Yeah.
And if one turns to the World Heritage Convention, at tab 57 of the authorities bundle, page 2443.
Two, four, three.
2443.
Yeah.
So we start with the recitals. Ask your lordships to look particularly at the second recital, considering that deterioration the sixth recital, which is considering that parts of the cultural and natural heritage the last recital, which is recital 8.
Sorry. The recitals actually begin with noting, yes?
Yes.
Right, so that's
yes,
one.
That's one, apologies, yeah.
Yeah. And you want, which ones you want? You want
2,
two.
6 and 8.
Okay, 2, 6 and 8.
And then turning to page 2445, we have Articles 4 and 5. Article 4, each state party to this convention recognises the duty of ensuring the identification, protection, conservation, presentation, etc., to future generations of the cultural and natural heritage referred to in Articles 1 and 2. Belongs primarily to that state. It will do all it can to this end to the utmost of its resources, and where appropriate with international assistance. And then Article 5, to ensure that effective and active measures are taken for the protection, conservation and preservation of the cultural and natural heritage. Each state party to this convention shall endeavour, insofar as possible, and as appropriate for each country. And then there's a list of A to E measures in various categories. So, for example, D is taking the appropriate legal, scientific, technical, administrative, financial measures necessary for identification, protection, conservation, etc. So, my Lord, our submission is that there is discretion on state parties as to the means by which they protect and conserve. But there is not discretion as to the ends. The lens is one of ensuring protection, conservation, etc.
So that means the Secretary of State's got to decide whether to get the money from the NHS, the Defence budget, or the Cultural Department, or what?
Well, my Lord, the Secretary of State has to ask, has the UK done all it can to this end to the utmost of its resources?
Well, I mean, Great Britain's GDP is sufficient to do a tunnel from wherever you like to wherever else you like. But what does this mean in practice?
Well, my Lord, it means in practice the UK has to protect and conserve the World Heritage Site. Now we're looking at this through the lens. Of course, we're looking through this through the lens of a road scheme which involves a motorway going through the World Heritage Sites.
Yes.
But actually, if the UK did nothing, it would be protecting and conserving.
So on that basis, they've either got to do nothing, or they've got to take a tunnel from east of the East Portal to west of the West Portal.
Or the Southern Bypass route, my Lord, which was £400 million cheaper. So it requires the Secretary of State to ask, has the UK done all it can to its end, this end, to the utmost of its resources?
But that, I know I put it rather tendentiously to begin with, but that means, on your submission, that a World Heritage Site trumps everything.
Under the World Heritage Convention, yes. Under the statute, no, because the Secretary of State can decide that there is a breach of the convention, but he's going to go ahead with it nonetheless.
Do you submit that any policy, and I'm obviously thinking about the NPS-NN, which incorporates a balancing exercise between harm on the one hand and benefit on the other, would necessarily for that reason conflict with or be inconsistent with the convention?
It depends how it's applied,
Well, does it depend on that, or does it depend on what it says?
I think it does, because under the NPS-NN, the scheme could have been refused because the harm would outweigh the benefits. No, there would be no...
Yeah, but that's the application of the policy, together with other material considerations. But just looking at the policy as it is written in the NPS-NN, which is a balancing exercise, is that incompatible with the convention, and in particular the commitment in the convention to do all it can to the utmost of its own resources?
If that is to be the be-all and end-all of the consideration, then yes. But we say that the World Heritage separately has to be considered. So one can apply the policy test. UK government says, well, we think it's more important to relieve traffic congestion. But what we say is because of 104.4, the UK government also has to look at the World Heritage Convention. And that is a different test.
And where he's gone wrong, we don't have to decide whether or not building Stonehenge in any, building the road in any form, or preserving the existing one. We don't have to decide whether that would be a breach. What you're saying is there is a failure by the Secretary of State to address a separate question. I've acted in accordance with my policy, full stop. But nonetheless, I should also consider not acting in accordance with my policy to give effect to an international obligation.
Yes.
Is that it?
Yes, my Lord.
But if the policy is the way in which in domestic law we give effect to the World Heritage Convention, how can we force a different policy on him? Because that would be to force a change in policy to give effect to an unincorporated association.
Well, there's nothing in the NPS-NN which claims that this is how the UK, and this is the only way the UK is giving effect to the World Heritage Convention.
But it's different, isn't it? If it's an unincorporated treaty, don't you have to find something that says that treaty is the trump card? And the Secretary of State has got to consider playing that trump card. And if there's nothing that says that is what he's got to do, don't we just have to read the policy? Unless he said, these are the words I'm using, but I'm intending to make sure that those words mean whatever the convention means, like Section 3, effectively, of the Human Rights Act.
Because of 1044, my lord, Section 1044 of the Planning Act, the Secretary of State was required to consider whether the application would breach international obligations. He decided that effectively the MPSNN was dispositive of that issue. We say that is wrong, and it is indeed an untenable approach when there is a proper understanding of the terms of the World Heritage Convention. My lord, to put it, my learned friends have said, well, Articles 4 and 5 should be interpreted as well, all bets are off, and state parties can simply, as a matter of judgment, decide to do what they like with World Heritage Sites. But then that begs the question, well, what on earth is the point? You know, if the Egyptian government can decide to run a motorway through the pyramids of Giza and say, well, we think the benefits outweigh the harms and we're acting in accordance with the convention.
But that's to try and enforce. You need an international court of culture, like you've got the International Criminal Court and so on. If you're a dualist society and international law doesn't come into domestic law, it isn't enough to say, we think it would be a good idea to be bound by international obligations. You've got to show, under a dualist system, how that comes into effect. There are constitutional reasons why. It's not for the executive to agree treaties, which then compel the use of public money, because that's a democratic thing. So you've got to address that. It's not enough to say, we'd like to live in that world.
No, that's why I addressed your lordships on 1044.
Yes, it is 104 or nothing.
It's 1044 or not, yes, I perfectly accept that.
But the next problem that I've got is that under the decision letter back at 619, the Secretary of State says he's satisfied it's in accordance with the NPSN, and he's satisfied that this would not lead to the UK being in breach. So he's satisfied of that. So do we have to go on and say, no, you're wrong?
Because he's conflated the test under Articles 4 and 5, those obligations, with what is required under the NPSN.
Well, that's the question. Has he done that at 619, or are they separate?
Yes, my lord, he has done that. And I mean, the reason we know that is, of course, because he has found harm overall to the World Heritage Site. And I took your lordship through all of the very striking findings with which he has agreed.
Well, I'm sorry if I'm cutting you across, but it does bring us back to the question I asked, I think. Because if you can't construe, or whatever approach you adopt, Articles 4 and 5 as admitting of any balancing exercise, and the NPSNN manifestly embraces a balancing exercise, then your submission is, and I think it is actually, that you can't construe the NPSNN as being consistent with the Article 4 and Article 5 commitments.
Well,
is that right or not?
Yes, I think it is right.
I mean,
one has to, because it's separate. It's a different test.
When don't you need to make that submission to be able to make the submission that you are answering? Which, as I understand it, is that it's simply impossible for him to say, lawfully, that compliance with the NPSN is tantamount or sufficient for the purposes of complying with the convention.
But it's because Articles 4 and 5 do not.
They don't admit any balance.
Yeah.
You say.
I say.
Then that's a question of dispute between yourself and your opponents.
Yes, my lord. But because of the time, if I could just ask.
Well, but before we do that, what about all the other things that have got to be taken into account? You showed us lots of criteria, whether it's serious harm and so on. Somebody has got to make an assessment as to whether or not there would be that kind of serious harm, doesn't it? And I thought that would be the committee. I didn't think it would be us or the Secretary of State.
Well, it is, my lord, by virtue of 1044, these are international obligations. Everyone agrees Articles 4 and 5 are international obligations.
Yes, we've got that.
So it's the Secretary of State who has to reach that judgment.
He's got to decide. He's actually got to apply the operating guidelines and the criteria and reach a decision on whether or not it would or would not be on that list if he puts the road through.
No, because the list is separate. The duty is on the UK to do all it can to protect and conserve the World Heritage Site to the utmost of its resources.
You say that to grant development consent for a road scheme that manifestly does harm to the World Heritage Site cannot be squared with that obligation.
Yes.
I mean, again, it's not very complicated.
No, it's not very complicated.
I think. Well, the essence of it isn't.
So, sorry.
The essence of it is.
The essence
It's not.
of it is
It's
not
not
complicated. And my lord, just in support of the appellant's interpretation, I just ask your lordship to have regard to paragraphs 4, 7 and 15 of the operational guidelines. They're at tab 58.
Paragraphs.
4, 7 and 15.
4, 7 and 15.
That's another problem that I've got. I understand the convention. I do understand what you say about that. I'm not clear in my own mind how it is that the operating guidelines, I know you've shown us paragraph 1 and 2, how they enter into domestic law, because they seem to be the guidelines that the committee uses when it decides.
My lord, we are inviting the court to interpret Articles 4 and 5. The court will have to decide whether it does that on an objective interpretation or whether it simply looks at whether the Secretary of State has taken a tenable view. But either way, it's going to have to construe the articles. Mm-hmm. We say that the operational guidelines, which are drawn up by the committee, are relevant to the interpretation. Historic England draws the court's attention to one paragraph of the operational guidelines, which is 118 bis.
But is there anything in the Vienna Convention on Treaties that say you look at the operating guidelines drawn up by a committee that operates it? It's a big question of interpretation. And there's a lot of law on this, and you can't just say, oh, national heritage, refer to 118. There is law on interpretation of treaties.
Yes, my lord. Well, we just simply invite the court to give an objective interpretation on the basis of the ordinary language used in line with the Vienna Convention. And I think we've got the case of Amalfi and Reyes in the bundle. But well, it may be the court decides not terribly interested in the operational guidelines.
Well, no, I don't know whether I should be interested or not. That's my whole point. If you're telling me that the Vienna Convention or a case law says that a document adopted by a committee in carrying out the obligations of the convention are relevant to the interpretation of the convention or are part of binding international law which the state party has to give effect to as well, then I'm very interested in it. But otherwise, I could read lots of things.
No, my lord, I'm not saying that. It was in response to some paragraph that was relied upon by Historic England. But maybe that I just deal with that in reply. My lord, the court does have some jurisprudence from the Australian courts on this issue. There's the Tasmanian Dam case, which is at tab 55 of the authorities bundle. Well, it's a very complicated authority. It was to do with the government of Tasmania wanted to proceed with a hydroelectric dam on the Gordon River. Commonwealth government did not want it to proceed. Sees that paragraph 1 on page 2265. Because it would cause harm to the World Heritage Site. The Commonwealth government enacted legislation to the effect that the project couldn't proceed. And the issue in the case was whether the legislation and the regulations made under them was valid. So it was a constitutional question of Australian law. And in order to answer that question, the court had to decide whether the World Heritage Convention imposed obligations or not. So that was, and that one sees that at paragraph 108 of Chief Justice Gibbs's judgment. Well, if I could just give the court some references, and they are skeleton. But just, one has to be quite careful with who was in the majority and who was in the minority. The majority judges were Mason, Murphy, Brennan and Dean. It's footnote 49 on page 33 of this bulletin. And with regards to Mason's judgment, if I could ask your lordships to look at paragraphs 29 to 31. Murphy is page 2335.
Paragraphs?
61.
Thank you.
Brennan 39 to 41. Page 2361 to 2362. And Dean at paragraph 24, 2380. So, in my submission, those, insofar as it goes, supports the view that one, there are obligations, but again that's agreed in this court, but two, the discretion on a state is to means, not actually ends. One sees that particularly in Mason's judgment. So, my lord, overall, the appellant's case is that the Secretary of State's approach to the World Heritage Convention was unlawful because he treated it as being, effectively as the MPSNN as being dispositive of that issue. But he had failed to apply the correct test, which does not allow for the balancing exercise, as I've taken the lordships to. And, my lord, those submissions really encompass why we say Mr Justice Holgate erred, and the reasoning is found at paragraphs 210 to 223 of the first judgment, which is in tab 47 of the authorities bundle. My lord, just briefly, paragraph 215, the judge erred in finding that the convention would have to be incorporated for the court to interpret it. We say that was incorrect. Holgate also relied on the fact that because the breach of the convention is a matter of judgment for the decision maker, meant that an objective interpretation shouldn't be applied by the courts, and we say that was an error. And third, that the judge failed to have regard to the purpose and of the convention as a whole. In any event, we say he was also wrong on the issue of tenability, which was a statement he made in the most recent judgment. My lord, I'll have to find a reference to that.
Now, Miss Hutton, how are we getting on?
That's done.
Is it?
Yes.
So that's the submissions for you.
Yes. My lord, just your reference in the first judgment, sorry, the second judgment is paragraph 76.
Sorry, the references you gave just now.
Were the first judgment.
So that's in Stonehenge 1.
Stonehenge 1. The reference in Stonehenge 2 is paragraph 76 to 80. And it's CHB 1, page 455.
So I've got paragraphs 210 to 223 in Stonehenge 1,
Yes.
76 to 80 in Stonehenge 2.
Yes.
Thank you very much.
Well, thank you.
Thank you. Thank you very much, both Mr. Wolf and Ms. Hutton. Thank you. Mr. Clement.
May it please my lords, I appear with my learned friend Miss Grogan on behalf of the Secretary of State. We've lost a few minutes,
Yeah.
but I hope I can compress my submissions so we still reach the close time. I'm intending to address most of the appeal grounds, and Miss Grogan, who has been involved throughout, unlike me, will deal with appeal ground 7, which is paragraph 69 to 73 of our skeleton argument, and also particularly dealing with the facts, the treatment of alternatives, not just the longer tunnel, but the route which is now known as F10. It hasn't been easy to respond to the many grounds, particularly as they've mixed the Court of Appeal grounds and the JR grounds for understandable reasons. But I will try and focus on the grounds of appeal and then go back to JR grounds when I have to.
Yeah. Thank you.
The judgment of the court below, which I will be referring to often, is based on and applies well-established principles in this area, and concluded that none of the grounds of challenge as amended were arguable. It was, as you will have seen, a lengthy and considered judgment, and there was no, in our submission, error of approach. There is a basic issue here at the heart of at least some of the grounds of appeal, and in order to look at that ground, it will fall to this court to consider those well-established principles, and I don't shrink from that task. In our skeleton argument, paragraph 9, we've listed the grounds of appeal under various headings. Alleged errors by the court in relation to briefing, and we put that together with appeal grounds 1 and 2, and they are covered in paragraphs 12 to 34 of our skeleton argument. Alleged error in relation to fairness, and that's appeal grounds 3 and 4, paragraphs 35 to 49 of our skeleton argument. Then we move on to slightly easier grounds in order to compartmentalize them. The risk of delisting error, and that's appeal ground 5, 50 to 60 of our skeleton argument. Then the matter you've just heard, alleged error in the court's approach to the World Heritage Convention, appeal ground 6, paragraph 61 to 68 of our skeleton argument, and finally the alleged failure relating to the review of the NPS, appeal ground 7, paragraph 69 to 73 of our skeleton argument. Appeal grounds 5, 6 and 7 are reasonably self-contained, but grounds 2, 3 and 4 are it's inevitable that we'll drift into the other JR grounds. I will go through them as quickly as I can, but I may have to, as I say, dip into the linked JR ground. Could I take paragraphs 1 to 11 of our skeleton argument as read, but mention just 2 points. Paragraph 9 on page 47 of the core bundle refers to the client Earth case that there's no reference on my page. Could I add tab 45 in volume 3 at page 1848? My lords, Lindblom and Lewis were in that court, but the main focus was on section 1047 of the Act.
Yeah.
We set out under a heading applicable principles in paragraph 12 various sub-paragraphs which are at the heart of our submissions on the approach to ministerial briefing. So this is appeal grounds of 1 and 2. And we refer in the first line to the first instance judgment at paragraphs 139 to 149. And could we invite you at what passes for your lordships? I'm so tempted to say leisure, but I can't use it. But if you can read those paragraphs, they summarise the principles far better than I can. In the footnotes, you will see, sorry, in the references, you will see references to various cases. And I don't need to go through all of them. In the judgment, if I could just take you to the paragraphs 139 to 149,
Yes.
and the page is core bundle 203 under the heading legal principles. And this is dealing what became ground 8. The brief, and to summarise ground 8, the briefing to the minister was legally inadequate. And various cases are referred to. Some of them you will have seen already, but to give you a reference, for example, to one of the most important cases, Friends of the Earth, that's in paragraph 139, that's tab 43, volume 3. In paragraph 144, there's reference to a case that you may not have seen right at the end. It's the Transport Action Network case. It's another decision of Mr Justice Holgate. It's at Appeal Bundle 3, tab 48, page 2016. The only reason I mention it is that in that judgment, the judge at paragraphs 60 to 79 gave, in our submission, a very good summary of the applicable law, and we invite your lordships to read those paragraphs. So it's 60 to 79. And in the middle is the paragraph that he refers to, paragraph 73. So could I take paragraph 12 also as read, and then turn straight to ground of appeal 1?
Yeah.
And the grounds of appeal are in the core bundle at page 126. And the ground is as follows. The judge erred in assuming the minister considered documents available to him merely by provision of the examination library web link. The short answer to that question and that ground is that he didn't. He made no such assumption. Therefore, we don't need to go further. But in the course of exchanges yesterday, there was reference to case law, and could I just leave for another occasion but mention it? There is a reasonable argument, particularly in our modern times, that a decision maker faced with a mass of documents can be assumed to dig further if in a document he is referred to another document and there is a link, without him having to go on oath and say, I clicked the link, because there is here no witness statement from the minister.
Yeah.
or at least then ask his officials or her officials, how do I access the link if there's a problem? But it's just there's a reference to the Suffolk case, which I'll touch on. Again, Mr Justice Holgate. But I don't want it, because the judge didn't deal with it, I don't want the court, unless it has to dismiss the use of web links and hot links.
No.
So before I go to this ground in detail, a bit of context. As I just said, there's no witness statement from the minister. He was an experienced member of Parliament with particular experience in transport matters. He served for many years as a member of the Transport Select Committee, and for some years he was its chair. He didn't stand at the last election. This is all from a witness statement I'll come to. There is nothing to suggest that he didn't do his job properly or was incapable of asking his officials to provide more information or make more inquiries before he made his decision. And there was a month between the submission on the 24th of May 2023 and the decision on the 27th of June. We deal with this web links point very briefly in our skeleton at 3 paragraphs. Again, I won't take you through them, give you the references. It's paragraphs 13 and 14 at core bundle page 49 and 19E at page core bundle 52. The judge addressed this point also briefly as part of a section of his judgment on implications of the claimant's argument, and that's paragraphs 150 to 159. Could I take you to those briefly? They are on page core bundle 206 and following.
Yeah.
And this is where the learned judge at paragraph 150 sets what he calls the threshold question. And I'm not going to read through those paragraphs, but again, could I ask you to, of course, read them again, and we say they're all correct and right. In paragraph 156, as part of this section, there's a reference to hyperlinks. Similarly, so if you, perhaps because of the word similarly, if you could run through 155 before I pick it up at 156.
Yes.
Similarly, there is generally no need in planning cases for the court to be involved in what seems to be becoming satellite grounds of challenge. Not only is there argument as to whether the ministerial briefing disclosed was adequate, but also whether the hyperlinks in such briefings provided adequate signposting as to what, if anything, the minister should read in other documents. Time was taken in this case on just such a point, that is the adequacy of Annex A to the ministerial briefing, when in my judgment it has no significant bearing on the real merits of the ground of challenge, including ground 8.
Yes.
The judge returned to the same point somewhat obliquely on page 211 of paragraph 177. And he refers back to previous paragraphs summarizing the law and says this: both in the examination and decision-making process, it was a matter of judgment as to how much evidence was obtained, how far the comparative exercise should go into that evidence, and how the impacts compare. There is no legal reason as to why officials, rather than the SST, could not make those assessments in order to assist the Secretary of State. he was entitled to rely on brief summary judgments prepared by officials without being obliged to consider the underlying evidence on which those judgments were based. See, for example, paragraph 218 of the decision letter in the same bundle at page 645. And then it's this sentence. In the usual way, the Secretary of State for Transport was able to ask for more detailed briefing on a particular point, or to look at specific documents if he so wished. In addition, the SST had access to the underlying material. Mr. Wolf's contention would apply not only to this particular comparative exercise in the present case, but more generally to ministerial decision-making in planning cases and to many of the various issues they would raise. So the Minister had access to the underlying material. It doesn't then lead to a conclusion from the judge that he assumed that Mr. Merriman actually clicked on any of the links. As I mentioned a few minutes ago, there is also the Suffolk Energy Action case. You've been referred to it, so I can take this shortly. Could you at some time look again at the Suffolk Energy Action case, volume 3 of the authorities, tab 50 at page 2080, at paragraphs 142 to 145 at page 2116, where at paragraph 144 he does address the issue of presumption. So what we have, what is, I hope, clear from the material, and I'll go to it now in a bit more detail, is that there is consideration, analysis, testing, etc. by the officials, but as required by section 103, the decision was made by the Minister. So ground 1 can be answered in that brief way, but before I leave the topic, could I take the court to a little more of the evidence? You were taken by my learned friend Mr. Wolfe to the witness statement of Martin Gilmore, the deputy, or the then deputy director, Planning, Housing and Transport Division at the department, and the person who signed the decision letter. His witness statement is at supplementary bundle 3, page 157. You've been taken, if I recall, to paragraph 8 onwards, which deal with applications for road schemes, DCR applications in the general sense, noting that paragraph 12, that the usual submission is a 2-page document, because there was a hint of criticism that this submission was too short. Then, when looking at this particular application, with paragraphs 15 and onwards, I think you were asked to look at 22 to 26, but 15 to 19 are a useful summary. Mr. Gilmore explaining at paragraph 3, going back to page 158, why he's making this statement. It's the 4th line. In particular, this statement supports the Secretary of State's response to the claimant's application to amend the grounds of appeal, that's ground 8, to add an additional ground alleging inadequacies in the briefing material provided to Minister Hugh Merriman before he made the decision. What I wanted to take you to was then a little further, which is paragraph 27 onwards. And there you can see the witness, Mr. Gilmore, explaining what happened and what was being provided. And could your lordships read on to the end of paragraph 33.
Yes.
You've had reference to the annexes which are listed in paragraph 32. For those of you who have a paper copy, the submission in the top line of paragraph 32 is at supplementary bundle 2 at page 17. It begins at 17 and it's at pages 19 to 20. The annexes are listed. The third one is Annex C, and you were shown the emails, it being accepted by Mr. Wolfe that all the tables which were annexed to Annex C, full of detailed information, were seen by the Minister. The draft decision letter you've also seen. What you haven't seen in detail is Annex F. That becomes an important document when we look at ground 5, that there was no regard to the decision, or part of ground 5 that's now framed. There was no regard by the Minister to the decision 44 in July 21. And I'll, of course, come to Annex F later. In paragraph 33, that's the reference to the hyperlinks. That paragraph was challenged by a witness for the appellant, responded to by a government lawyer on behalf of the Secretary of State, and it led to a statement of common ground. And so it might help just to see it briefly. It's core bundle, page 430. Parties agreed the following in respect of what had been disputed in those two witness statements. And again, if I could invite your lordships to read paragraph 2, which is taken shortly, but it does explain in rather fuller detail than my learned friend's summary the usefulness of Annex A.
Yeah.
So what this supports is the paragraph in the judgment that either the Minister could access the documents, particularly the important planning documents, or he could ask his officials for more information, and for some ministers, how to access a hyperlink. The next part of Mr. Gilmore's witness statement deals with alternatives and climate change policy at paragraphs 39 to 52, supplemental bundle 3 at page 167. I don't ask you to look at that now, those are topics to be covered by Miss Grogan. As we know, the Minister specifically said to have, quote, considered all annexes in order to reach his decision. That reference is supplemental bundle 2 at page 319. As you have seen, Annex B was the draft decision letter, and there are repeated references to consideration of responses of the interested parties, including the appellant. If I can give your lordships just a few references, and there are many more: 18, 19, 20, 21, 82, 85, and 91. So 18, 19, 20, 21, 82, 85, 91. Lord Justice Lewis considered the word considered in a question. What does it mean when a minister in a decision letter says, I have considered responses? And does it mean considered personally, I have read all the underlying documents? Or does it mean I, together with my officials, have considered the documents? Or is it a mix of both? But as long as the minister is making the decision, which he is in this case, it's either one of those or the other, but it doesn't mean not considered.
Does that bring us back to where we started?
Yes. There are a few circles in these submissions. We end up back with Friends of the Earth, paragraphs 116 to 120, which are now sadly engraved on my retina.
But does it mean, in substance, directing one's mind to and reflecting upon? What does it mean in practice?
It means that.
Yeah.
But unless we have, or the court expects, a witness statement from the minister saying, well, I know it was a couple of years ago, but this is what I actually did. I was sitting in my, etc. It's a use of words you see regularly in such documents. I considered, and it means all that the word considered means, but it can't mean unless the minister says, I have read all 3,547 pages, whatever it is, that's in Annex A. But it must mean that he has either considered the documents as filtered to him or in discussion with his officials, which is also not to be underestimated. They don't sit in separate bubbles. But it appears regularly in the letter. At this point, I was going to go on seamlessly to ground of appeal 2, but it's necessary to touch ground 8, the legal adequacy of the briefing. This is covered in the judgment at paragraphs 139 to 178, core bundle 203 to 211, and the appellant, as you have heard, perhaps unhelpfully combines judicial review grounds 8, 2, 3, and 6 under this heading, inadequate briefing. And it seems that there are two categories. Without going through them, I'll just mention a couple. First of all, matters that the minister might have considered important and relevant, relying on the exercise of discretion under section 104(2)(d). And that's in their skeleton argument at paragraphs 19 and 27 to 28. And amongst those are, should the examination be reopened, the longer tunnel brings benefit to wildlife, the impact of route F10, etc. Some of these grounds were not developed in front of the High Court, but I'll touch on them very briefly. The other are mandatory material considerations. This is appeal skeleton, paragraph 43 at core bundle page 16. One of them is the risk of being listed on the World Heritage in Danger. and it is now said to be separate from the risk of delisting. I say that just to get it out. In the original ground, the focus was on delisting. Then route F10 was cheaper, so cost is mandatory, and then reasons for review of the NPS, which is JR ground 6, now appeal ground 7. So of those various elements, longer tunnel benefit to wildlife, traffic forecasts, heritage impacts were not pleaded or developed in front of the first instant judge, I'm told. Therefore, there is no detailed response. But I can touch on two of them briefly and then move on. The first one is the longer tunnel would bring significant benefits to wildlife. As far as I can see, this is one paragraph in the various submissions. This is the April 2022 submission of the appellant at Supplemental Bundle 2, page 257 at 259. And without going through it, my lords, this is, I can read just the first few words. It's part of a response dealing with the broad tunnel extension. And this is the reference to the stone curlew. You may have seen the stone curlew walking across some other paragraphs. It's one paragraph, not supported by any detailed analysis or alleged environmental benefits, but the impact of the scheme on stone curlews had been dealt with, and I'm trying not to go too far into the facts, but I can give you some references. In the examining authorities report in Supplemental Bundle 1 at pages 23 to 27, and the main paragraphs of paragraph 5.538 to 5.560. And as part of that analysis, the examining authority records that the RSPB and the applicant, National Highways, had agreed a statement of common ground that construction impacts on stone curlews could be avoided. It's then dealt with in the decision letter. Again, I won't take you to it. At decision letter paragraph 183, core bundle page 638, when the conclusion was that this carries neutral weight. And at decision letter 200 to 205, core bundle 641 to 642.
Sorry, decision letter 200 to 205?
200 to 205, core bundle 641 to 642. And he concluded that there's no adverse effects on the integrity of the Salisbury Plain SPA.
And he refers to the stone curlew.
He does, specifically.
201, I think.
Yes, yes. And there are more references, I won't bother you with more. The point is dealt with in the judgment at paragraph 163 to 164, core bundle 209, where the judge addressed this ground in rather strong terms. The second topic, and it may be sensible to keep the judgment open at this point, is 171. It's 131 and 171. This is the traffic forecasts. This is core bundle 210 and 2024. In summary, or in short, the traffic forecast was dealt with in various submissions. This is the likely or possible effect of COVID-19 and different uses of that data. If I can give you the references again without taking you to it. The appellant submissions on this point are in supplemental bundle 2 at page 211, and this was April 2022. The complaint being that National Highways' approach of developing a single central case was unreliable, and then COVID-19 had led to major changes in travel. The first point was set out and then responded to by the examination report, and again, if I can give you the reference, it's supplemental bundle 98 to 99 at paragraphs 5.17.60 to 5.17.68.
I'm sorry, Mr. Fleming, I ought to know which bundle it's. It's
supplemental bundle 9899. Volume 1, I'm sorry.
Thank you.
And in the decision letter, as we've heard from Ms. Hutton, the Secretary of State can be taken to agree with the examining authority by virtue of paragraph 20. You've been taken to that already. That's core bundle page 598. And at paragraphs 26 to 28, at core bundle 599 to 600, the Secretary of State agreed that the scheme would meet future traffic needs and deal with the existing problems with congestion.
Sorry, the paragraph numbers?
26 to 28.
Thank you.
And again at paragraph 39 on page 601. COVID-19, I won't bother with it. It was specifically referred to in the decision letter at 161, core bundle 633. So the Secretary of State was aware of the point and took a rather longer view on traffic than the lockdown provisions of COVID. So one other, and I'll mention the heritage impact. No, I'll leave that to Ms. Grogan. It's on alternatives. And the other points I think I can deal with separately. Could I move then to ground of appeal 2 and take that over the next 5 minutes or so? Yes. This is as follows. Part 1, the judge erred in law in holding the minister needed personally to consider only what is in law obviously material, and 2, the judge erred in law in concluding that the minister's briefing did not omit obviously material considerations. Now, this important point, for other cases as well as this, is predicated on 3 givens, as they are called. First of all, section 104(2)(d) of the Planning Act. Secondly, consultation principles. That's Moseley or Sterling as it's sometimes called. And thirdly, the minister's need to consider evidence supporting his conclusions. Those bases are addressed in our skeleton argument at paragraphs 17 to 20, and that's core bundle 50 to 53. And I return again to one of the circles, because as a preliminary point, where we started, the established approach to alleged failures to take into account evidence or submissions in this type of case is that sent out in the Friends of the Earth case. Authorities Bundle 3, tab 43, 1793 at pages, the paragraphs 116 to 121. That was the approach taken in Stonehenge 1 on the basis of an agreed statement of legal principles. And I won't take you to it, but it's Appeal Bundle 3, Authorities Bundle 3, page 1939 at page 006, 2006, at paragraph 1E. The correct approach is that the Minister, in making a decision whether or not to confirm a DCO, has regard to information which he must consider either as a matter of legal obligation or alternatively, matters so obviously material as to require direct consideration by the decision maker, and it would be irrational for him not so to consider.
I do apologise, I didn't get the page reference in the authorities bundle.
It's AB3, volume 3, page 1939 at page 2006.
Thank you.
And it's paragraph 1E.
Yes, I got that.
Section 104(2)(d) is a bit odd, the relevant, important. It doesn't sound like mandatory, although it sounds closely related. But it sounds a bit more significant than things that potentially he could take into account, but might choose not to.
It's 104(2)(d) has taken a lot of time so far. It's a, in our submission, it's a wrap-up provision.
And what does that mean?
It means that as we go through that subsection, the Minister is given freedom not only to consider, obligations not only to consider listed items, but any matter where he is satisfied, either by his own inquiries or by however else he reaches the information, that there are other matters that he considers are both relevant and important. So, which the Secretary of State thinks, classic language. And that, we say, doesn't overrule or negate the familiar case law and obviously material. And this is the judgment of paragraph 152, core bundle at page 206. This is what the judge says. The decision maker does not have to work through each and every consideration which could be regarded as potentially relevant to his decision and positively decide whether or not to take them into account in the exercise of his discretion. That's paragraph 152 of Mr Justice Holgate, which he then was judgment. The alternative, and this came out in exchanges yesterday, is that the Minister or the Secretary of State commits an error of law unless he either receives a summary on every point from his official so that the Minister can decide whether or not, one, that point is relevant, two, it's important in his opinion, or he has to read everything. And that may be the answer, and it may be the answer when we mix this with the second point, consultation, but it would be a surprising outcome against this background. Could I mention one case and then pause for the short adjournment? We say the correct summary of the law as we set out in paragraph 12 of our submissions and as set out and summarised by the learned judge is not contradicted by section 104(2)(d), even with or without the reference to what the Secretary of State thinks is both important and relevant. My learned friend Mr Wolfe referred to the Pierce decision. Again, I won't take you to it, but could I give you the reference? The learned friend referred to paragraph 11 of that judgment, again, Mr Justice Holgate, at Authorities Bundle 3, tab 44, at page 1813. Well, maybe I could I'll just read it then sit down. It's, as I said, tab 44, page 1813. The reason I wanted to take you to it is my learned friend stopped reading, and it's the rest that is important. So it's paragraph 11 on page 1813. This is what was read to you. Section 104.2d allows the Secretary of State to exercise a judgment on whether he should take into account any matters which, I add in, he thinks to be relevant but not mandatory material considerations. It's the next bit that wasn't read. This reflects the well-established line of authority which includes Creed, Findlay, Oxton Farm, Friends of the Earth, paragraphs 116 to 120. So we're back in that circle again. My Lord, is that a convenient moment?
It is indeed. Shall we start again at 2 o'clock?
All rise, please.